Okay, I think we are live now. So good morning, good afternoon, good night to everyone. My name is Ricardo Ramirez from the National Autonomous University of Mexico. Roy Scranton reads that global warming is not the latest version of a horary fable of annihilation. It is not an hysteria, it is a fact. And we have likely already passed the point where we could have done anything about it. So to give us some hope, to give us some solutions, to give some handy solutions, I have the honor and privilege of having four excellent scholars who will try to take us through some solutions and try to see whether there is some light or maybe less light after the tunnel. And for that, we will go for the plan that we agree is that we will go from general to specific, and we will start with WTO solutions, and then we move to the Paris Agreement to try to find some solution. So we start with Emily Reid from University of Southampton. Emily, you have the floor for 7 minutes.
7 minutes. Thank you, Ricardo. I'll crack straight on. The recognition of the Anthropocene casts a stark light upon the impact of human activity upon our environment, framing the way in which we must now view and manage our interactions both with each other and with the planet and our environment. It exposes an imperative that we adopt an approach to our actions which holds human and environmental interests and rights in balance. Without that, we leave the future of the planet and all of its inhabitants in jeopardy. There are many implications of this, including for how we currently manage and do trade and trade regulation and the priorities that we apply around that. It is also clear that climate action requires us to face and engage with the imbalance between the responsibility of the global north for anthropogenic climate change and the impacts felt by the global south. Responding to this, in this paper, I turn to the concept of sustainable development, which already recognizes the interrelationship and mutual dependency of economic, environmental, and social development. The Sustainable Development Goals, or SDGs, are not only a statement of the international community's commitment to achieve sustainable development, but also a demonstration of both the interdependence of economic, social, and environmental interests, but additionally of the interconnections between contemporary global challenges that we face. Without tackling climate change, we will struggle to achieve the other SDGs. So pursuit of these goals requires a truly integrated conceptualization and operationalization of sustainable development, meaningfully balancing economic, environmental, and social considerations. The paper that I'm sketching is essentially concerned with what that might mean for the approach we take to trade and for the implications of this for the World Trade Organization and its interactions and the interactions of its rules with local decision makers and regulations. In exploring this issue, I'm particularly interested in SDG 17. Partnership for the goals. Now, these issues engage questions of global governance essentially applied to the trade context. They're vast questions, so all I can do here is sketch the three key issues I want to highlight. First, the challenge for global governance of a truly integrated conceptualization of sustainable development. Second, the potential and limits of SDG 17 partnerships for the goals. And third, the consequent need to reevaluate assumptions key to interpretation of WTO rules and their relationship with local rules and initiatives. First, the necessarily truly integrated application of sustainable development poses significant pragmatic challenges due to the fragmented or siloed architecture of international law. And secondly, because the traditional actors in international law are states, which does not recognize the emerging array of actors on the international stage. The pursuit and achievement of sustainable development requires that these distinct bodies of law and actors engage with each other, both horizontally and vertically. However, decision makers, particularly the emerging actors, including in dispute settlement, have a primary area of concern, for instance, trade, and limited, if any, mandate outside their own regime. This clearly affects the World Trade Organization. The approach to its engagement with environmental issues, and in particular national environmental regulation, has been much commented upon. I've highlighted elsewhere the kind of careful work done by the appellate body in seeking to remain within its mandate while mitigating the inevitable legitimacy questions when ruling on such issues, trade and environment. Whether meeting these concerns should be left to what might be termed judicial sensitivity is moot. Which brings me to my second point. Tempting as it might be to seek to redesign the international legal order and its institutions in pursuit of sustainable development, it seems unlikely that this can be achieved. So we must work with the institutions and the legal regimes which exist, rather than seeking to create those that we would like. In this context, it seems apt to turn to SDG 17, Partnerships for the Goals. SDG 17 is concerned both to improve the implementation of the Sustainable Development Goals in Agenda 2030, but also to enhance and improve collective action globally in pursuit of sustainable development. This recognises that while traditional approaches have not worked, we must use and make better use of the institutions and actors which exist. SDG 17, however, places a very strong emphasis upon economic initiatives and global partnerships and recognises therein the role to be played by the WTO. However, it's not until Target 1716 that we see reference to multi-stakeholder partnerships to support the achievement of the SDGs. And Target 17, buried almost at the bottom of the list of targets, seeks to encourage and promote effective public, private, and civil society partnerships. And this, for me, key target, acknowledging the need for engagement amongst a broader range of actors, resulting from which there might be genuine engagement with local views and decision makers, which are key to tackling climate change and achieving the SDGs more generally, is almost out of sight, almost as if an afterthought. And there is a real concern arising from this that SDG 17 amounts to a lost opportunity, entrenching, as French and Coetzee fear, a largely traditional understanding of the role of trade, finance, and international institutions, inter alia, in achieving development, even though it is now closed as sustainable development. So it is also not clear that SDG sufficiently promotes active participation of the Global South rather than imposition or oppression. So turning to my third point, however, it is clear that SDG 17, despite its limitations, does recognise the need to embrace broader governance to address the traditionally siloed approach to international law and governance. Increased participation in decision-making, particularly through the type of partnerships referred to in 1717, will also assist in addressing the inevitable questions and garnering support in the face of necessary trade-offs. Notably, therefore, SDG 17 engages the potential and imperative of polycentric governance. This carries significant implications for the locus and means of regulatory decision-making and the role of the WTO as a stakeholder in that decision-making process. The SDGs present us with a need to re-evaluate key assumptions key to the interpretation of WTO rules and their relationship with local rules and initiatives. And Goal 17 offers some indication of how this might be pursued in abstract. The question is, how might it be operationalized in order to ensure that trade is engaged to support measures to combat climate change and in support of sustainable development more generally? The preamble to the WTO agreement recognises the objectives of sustainable development. I've suggested in earlier work that WTO rules should be interpreted through a lens of sustainable development and that it is possible to give effect to them in that way. The more difficult challenge will be to reset the relationship between trade rules and national regulation and initiatives in pursuit of sustainable development. The international legal and institutional landscape is evolving, however, and trade law, including but not only WTO law, will need to evolve to reflect that.
Thank you very much, Emily. Now I will turn to Antonia to give us this view about North and South and how this plays on the global scenario. Antonia, please.
Yes, thank you. So the focus of this presentation is on sustainable development in the context of rural areas, and particularly in relation to agriculture and the need for food sovereignty. So there's two things that are undeniably true about climate change. First, we cannot mitigate climate change without divesting from fossil fuels. And second, our current globalized system of food production creates inefficiencies and vulnerabilities in supply chains that pose increased risks to populations, particularly in regions most vulnerable to climate change. Agribusiness relies heavily on fossil fuels to operate, and this just isn't sustainable. We need to reduce emissions, and if we want to achieve that, we must increase food sovereignty. So my perspective is rooted in living in Mississippi, which is the global South. The Mississippi Delta is a site of immense food insecurity, with most of the residents living in food deserts, despite being one of the most fertile areas of agricultural land in the world. In Mississippi today, large-scale agribusiness dominates, with international trade driving the ever-intensifying focus on monocultures such as soy. So when we talk about sustainable development, in debates, it's always the global north and the global south that are pitted against each other. But those who are most affected by climate change and environmental destruction are also victims of class struggle, which is a temporal continuation of class oppression. As such, reframing the struggle as between those who wield economic power and those who do not allows for a more inclusive framing that simultaneously centers local communities while internationalizing the problems and creating a basis for more effective global action. So when we take international rules and we apply them in a top-down fashion, we are ignoring those who've been most adversely impacted by the system, both in the global south and in the global north. So we can look at this through the lens of environmental law. Environmental law has been widely recognized as being all-encompassing and yet narrow at the same time, depending on whether it's viewed internationally or locally. And this dichotomy creates difficulties in linking international environmental efforts with local grassroots attempts to address immediate pressing problems of environmental law. Environmental law also has a temporal aspect. There's a multi-generational nature of the problems posed by resource mismanagement and climate change, and the problem seems even more daunting in that case. How can environmental law effectively regulate problems that began in the past and will continue for future generations? Where do we as individuals fit in? But if we view those affected by environmental destruction as the same people who are victims of class struggle, we see a temporal continuation of class oppression that goes hand in hand with environmental destruction. So class oppression and environmental destruction are to be read together. The problem that we often see with the top-down approach to sustainable development is that a one-size-fits-all approach is applied. And this places the burden on those who are not responsible for climate change to carry the weight of the climate change disaster that was created by global north industrial powers. People in the global north and in developed urban areas are quick to criticize those in the global south and even in rural areas of the global north for not protecting their environment enough. But at the same time, these same areas are criticized for being dependent on aid, whether it's foreign or domestic. So the global working class is viewed as simultaneously responsible for its own economic plight, while also being criticized for the environmental conditions where they reside, when in fact it's capitalism that's responsible for both. So how do we reconcile the WTO with the need for food sovereignty? International trade rules currently force local actors to fit their sustainable models within rigid rules that don't account for local specificities and thus exacerbate wealth inequality and power differences. In the area of agriculture, the existing rules are exploitative and extractivist in relation to global South countries, and food sovereignty is increasingly elusive as countries focus on single crops destined for export. You see an increase in control over land by small numbers of large agribusinesses, which continues to dispossess farmers across the planet and force rural residents into urban areas where their lives are even more precarious. And this is one of the key contradictions of capitalist control over agriculture and nature. So to transform an institution like the WTO into one that has real potential to provide an international coordination point for the fight against climate change will require interpreting its rules in a way that allows flexibility on the part of small farmers, grassroots activists, and local governments rather than vice versa, thus, as I like the phrase, localizing the global. The debate over food security in the WTO in 2013, which led to India's brief veto of the Trade Facilitation Agreement, which was really its only real leverage over countries that opposed the Food Security Initiative, is instructive. The reticence to accept even food security as a right for global South countries reflects a neoliberal trade-focused perspective that is opposed to food sovereignty and to things that would narrow the channels of trade. So the pandemic made us all aware of the fragility of GVCs. We shouldn't let this crisis bypass us. We have to recognize the fragility of supply chains and the importance of food sovereignty and robust local food supply chains and take measures internationally and domestically to limit the ability of transnational corporations to control food supplies and the ability of foreign entities to own agricultural land. So perhaps this is a call for radical action, a call to turn the WTO into an organization that brings more constituents to the table and that reforms itself to include democratic participation by groups and individuals, that listens to activists and indigenous voices, and that recognizes the call for profound systemic reform before it's truly too late to address climate change. And perhaps this is too far-fetched of a call for an organization that's member state-driven and that bows to diplomatic pressure. But without governments and a central coordination point, domestic actions to change how we conceptualize the environment, rurality, and agriculture may be difficult to mobilize effectively in an international context. More broadly, how we view sustainable development and the lens through which we understand the relationship between people and the environment requires a direct look at issues of race and class that are too often ignored at the international institutional level. Thank you.
Thank you very much, Antonia. And to help us see the forest, literally, Gregory will have some words.
Thank you. Thanks very much. Everyone's been so the pressure is on. I want to discuss a bit about forestry management and in trade agreements and actually in trade policy more broadly. So in the WTO, in FTAs, and then I'm going to identify what I think is largely the inward turn with regard to trade and ... issues, and what that tells us about what's happening with trade governance and also what sort of issues it flags up. And it touches quite strongly, I think, on a lot of the things that have been mentioned already, particularly in relation to North-South relations. So as with a lot of issues in sustainable development, forestry management is one of those that is multi-led and multi-overlapping. So conceptually, it covers environmental law, it cares about this, but so does human rights, indigenous rights, trade law, obviously, rules around agri-foods and so on. All of this links up into biodiversity. So you've got the multiple different legal systems. You then have what is essentially, in spite of multilateral environmental commitments in the space of forestry management, and in the context of SDGs, SDG 15 is kind of the focal. But actually, we're really fundamentally talking about, when we're talking about sustainable forestry management, we're talking about national regulatory measures. Whether that's where the forestries manage themselves, whether it's along the supply chain where timber products and others are used for final. So, and then to add to that, we have the kind of operational technical challenges around forestries. So that's basically the idea that a lot of timber products get used in. So there's sort of, for those accustomed to dealing with rules of origin, change in tariff headings and so on, it's that sort of issue that we're thinking about. But with regard to keeping an eye on forestry and sustainable forestry, that of course means that chain of custody then matters a lot. Now, we have a bit of acknowledgement. The WTO less so, it's predominantly the TBD, which is sort of facilitative or a space in which discussion takes place. These are usually the go-to place for us. We think of how are we going to fix this issue, let's use the FTAs. And in practice, what we see is quite an interesting different set of approaches. Some members that just aren't interested in any inclusion, entirely legitimately given the sort of the capital negotiating, including these provisions. Some, like the EU in its traditional Christmas tree, references, but not much beyond that. There's a couple of agreements with Central and South American countries where there's specific reference to FTAs, which form part of the EU's domestic, quote, regulatory framework. The US, which has quite an interesting approach, much more focused essentially on government. So it's about pushing back, and we see this echoed in labor as well. The US-Peru TPA, for example, the US raised a number of concerns about the constitutional administrative structures of how Peru governs industries, right? So the idea of the independence of agencies. Less focused on the actual niche-specific issues and more focused on the governance in the labor as well. And then you have some others, the EFTA Indonesia, which kind of uses carrots of surface, gets better press. If we want to get out why I think probably not. We can do that later. What I think is interesting is the East African community, the EAC, and COMESA and ECOWAS to a lesser degree, acknowledging that forestry management and actual policies on forestry management need to go hand in hand with economic development and the economic of development through using forestry. It is very much a sort of utilitarian to this, and yet there is at least an acknowledgement that there's an economic dimension here, which I think is key and will come back. What we've then seen is really, and I think this, I would suggest this is a wider development, is we've essentially realized that adding chapters to FTA doesn't really do very much. It gets the constituents happy enough that maybe you can get something through a parliament, but it actually doesn't do much when it comes to changing behavior. What does do is, if you are a very large market, changing your requirements. So, for example, the EU changes its emission standards internally, and it changes how Korea makes cars. That's got nothing to do with the EU-Korea FTA, right? So we have this much sharper tool, and if we're interested in supporting forestry management, we might think that's a good thing, right? The EU timber regulation, which imposes due diligence obligations on private actors and private responsibility. The US Lacey Act does something similar in a different fashion. Australia has a scheme in place also, a legislative framework in place. China, most recently, has now been developing its forest law. So this all seems potentially quite effective and quite good. So what's the problem? Well, I'm concerned that one of the consequences of unilateral regulation, as opposed to even where power asymmetries exist in terms of bilateral negotiations and or multilateral negotiations, is these are not negotiated outcomes with external partners. These are negotiated outcomes from domestic political constituencies. And that is fine insofar as it goes. The problem is we then have a disproportionate burden imposed on actors in the South as a result of decisions being taken within a limited number of very large markets, because you have to have sufficient regulatory pull to be able to actually do this effectively. So that's why the real ones that are the real large producers and or consumers, particularly consumers of these products. So what do we do? Well, this is where I think both the WTO, but also the ISO have roles to play. So the TBT agreement, you know, it's designed to deal with this sort of stuff. This is the bread and butter of the TBT agreement. We have is the commitments under which there are many and very specific to support participation in developing countries, both in standard setting bodies and in the organization itself, I think are not met in the ways that they should. The line that we use is technical assistance and capacity building will be the thing to keep everyone happy, but whether that actually takes place or not is open. And then also a lack of engagement, meaningful engagement on both sides with the ISO and from the ISO also. So just to give you a very, you know, ISO technical standard 14067, carbon footprints. We have a technical perfect, but it's an unusual standard in that it sets out how further standards, including private standards, would fit into a framework of carbon footprints. And I think that's a more in terms of identifying public engaging bodies with technical assistance that then can engage with a form of meta-regulation engagement. And I'll leave it there because I'm conscious of time. Looking forward to discussions afterwards. Thank you.
Perfect. Thank you, Gregory. Now, Gillian offers us Paris Agreement solution. Gillian. We cannot hear you, Gillian.
Oh, it's done now. So thank you, Ricardo. And thanks to the conference organisers. The Paris Agreement largely leaves individual parties free to choose which domestic mitigation actions they take towards the agreement's temperature and other goals, but it also encourages, through Article 6, voluntary cooperative action by parties, and that's what I want to talk about today. Article 6 is important for the trade and climate analysis because it is, if I can put it this way, where the Paris Agreement gives the nod to or authorises carbon clubs. Paragraphs 2 to 7 of Article 6 establish mechanisms for voluntary market-based cooperative action, including for international trading and emissions allowances, while paragraph 9 establishes a framework for voluntary non-market-based approaches, or NMAs as they're called, and paragraph 8 briefly elaborates on the NMA's concept. The twin purposes of the NMA's voluntary cooperation or cooperative action framework are, one, to entice parties to ramp up the mitigation ambition they commit to in their nationally determined contributions, and these are the individual targets and action plans developed by each party, and two, to support the parties to be able to do this in an orderly and well-integrated manner. A final decision about the kinds of international cooperative initiative which may be established under paragraph 8 hasn't yet been made, but many kinds have been suggested in the ongoing Paris Rulebook negotiations. Some of these aren't likely to affect international trade in the WTO law sense, examples probably being fossil fuel subsidy reform or land reforestation programs, but many will because the mitigation objectives of these NMAs will be made effective through domestic regulatory measures applied to both locally produced and imported products. For example, measures implementing a joint carbon tax or joint technical regulations. It can make a great deal of climate policy sense, especially given the urgency to undertake such initiatives jointly. But what about trade policy? I've been exploring whether cooperative NMAs under paragraph 8 also offer a valuable opportunity to reduce legal tensions between at least some climate mitigation measures and WTO law disciplines. For example, the existence of an NMA behind a domestic mitigation measure will lend important context, situating the measure within the Paris goals. So thinking about the TBT and Article 20, for example, this can certainly inform the legitimacy and the necessity of a measure. The NMA process also provides an opportunity to develop sharp clarity as to the objectives of domestic measures implementing NMAs. This is extremely important for both Article 20 and TBT purposes, because the ultimate framing of the objective of, say, a domestic measure introducing a technical regulation will largely draw the boundaries around the reasonably available alternatives, will directly guide a WTO panel's calculation of a measure's contribution to the objective, and will enable correct identification of the risks which non-fulfillment will create. A third point is that negotiating an NMA will involve multiple parties in what is an inherently cooperative process under the Paris Agreement. And that agreement applies both formal procedural requirements and legal principles to that process. For example, procedural rules in the Paris Agreement covering the paragraph 8 process will bring environmental integrity to a domestic measure under an NMA. This occurs initially through the paragraph 8 requirement that domestic actions under an NMA must aim to enhance participation in and the achievement of those actions and targets in the parties' nationally determined contributions. And then, if parties want to claim mitigation achievements from the measures, which is a key purpose of creating an NMA in the first place, Paris Agreement Article 4 requires that those claims represent additional mitigation and that they've been verified under a rigorous, independent and transparent accounting process. In addition to this, Article 4, paragraph 15 requires parties to take into consideration the concerns of countries most affected by the impact of mitigation, or as they call them, response measures. This requirement means the NMA parties must find out what the impact concerns of countries are, and in the TBT context, for example, this would take them to a consideration of the design, architecture, structure, operation and application of their proposed domestic measures in the light of that information. Added to these procedural requirements, legal principles now deeply established in international climate law will also bear upon the way in which NMAs are established, negotiated and implemented. One obvious example is the obligations which the developed countries have towards developing countries under the principle of common but differentiated responsibilities. And that principle is repeated in the Paris Agreement Preamble and Article 1.2. So, taken all together, and if done in good faith, these Paris Agreement procedures and legal principles could steer us towards a system of cooperative arrangements which markedly enhances overall harmonisation of parties' disparate mitigation actions and counterbalances, to some extent, adverse trade impacts from the broad freedom of choice which the Paris Agreement gives to the parties. Thank you.
Thank you, Gillian. Let me try to sum up, and then what I will do is try to take the discussion further and ask some follow-up questions to each of you, and also give you a chance to address anything that was said by the other panelists. So I think if we can summarize, Emily argues in favor of resetting the relationship between trade rules and national regulation in pursuit, of course, of sustainable development. Antonia talks about the social imbalances caused by climate change and that we need an interdisciplinary approach to climate change and sustainable development. Gregory highlights, using forestry management as an example, the need for a real participation of the global South in creating disciplines related to the sustainable development, which goes beyond technical assistance and capacity building. Gillian offers an Article 6.8 of the Paris Agreement approach, which establishes a framework for non-market approaches as an avenue to mitigate climate change. Now, Emily, you argue that one avenue could be 17 of the AGDs, and that is trying to get public and private actors as well as civil society involved. How do you achieve that, given the lack of awareness and worst incredulity, for example, around climate change, and in turn, of course, sustainable development? Many would argue that what COVID taught us is an overall lack of coordination between governments and private and public actors. So how can we aspire to what you call a polycentric governance?
I feel like that's about, yeah, 5 minutes. I feel like that's about 5 questions in one, and they're all vast. And I mean, I've been looking at this and thinking about this, and I'm not quite sure really where to start with it. I mean, I think, if we start with COVID, the parallels, frequently there have been parallels drawn between the international global community's states' response to COVID, and their lack of response and lack of engagement with climate change. And there was a kind of early optimism that, perhaps, if you can say optimism in that context, but perhaps COVID might teach us that, we can mobilize in the face of a kind of a global challenge. And certainly we saw evidence, across multiple states of a willingness to prioritize a non-economic interest, public health, over economic interest. And there was a willing to set aside the standard kind of prioritization of the economy in order to pursue and protect public health. And we've seen that, but equally, I think we've seen that that's temporary. And if you look at what's happening currently in the United Kingdom, we can see very clearly what are perceived to be the limits of the state willingness to set aside economic considerations in order to prioritize and pursue public health. So there's that kind of sense that, okay, if we're being optimistic about it, COVID tells us it's possible to prioritize a non-economic interest over an economic interest. So we have that. And so we've got that as a short-term thing. But we also have the kind of recognition that, now the economic crunch, the squeeze of COVID, is pushing states to turn inwards. And there is unlikely to be greater international collaboration, cooperation on any front as states try and sort out domestically and sort out their internal affairs. And we see that gets kind of balanced off against the fact that, as the UK has pursued a very vigorous vaccination programme, and that arguably a very successful vaccination program, and that's great insofar as it lasts. But obviously, until the world is vaccinated, the UK remains vulnerable. And that has a kind of another parallel with climate change, that this is not something that one state can do everything internally and sort out the challenges of climate change internally, because actually climate change doesn't respect national borders, just as COVID doesn't. So just as there can be variants in the virus that will be vaccine resistant, that leave the UK vulnerable, even if it sorts out its vaccination, becomes fully vaccinated. So we can see that parallel. I'm not putting this very well, but we can see that parallel as well between the challenge of how we combat climate change and COVID. But then we also see that the whole world was mobilized to tackle COVID because it perceived a single problem facing the whole world. And it manifested in the same way with different, clearly very, very different levels of kind of intensity and outcome and implications into impact in different states, but essentially the same problem manifesting, and the whole world could look at that problem and decide how to react, and even then has not managed to cooperate. Whereas actually climate change, for a long time there has been this kind of lack of credulity or incredulity about climate change, the lack of belief, but there has also been, it's been complicated by the fact that actually climate change has been seen as a problem that affects other states. For many who have the power to address and to tackle, and the responsibility to tackle climate change. And I think this really kind of is going into Antonia's territory here, I think, to some extent. But, you know, clearly climate change has not been seen as something that has particularly affected the global north, although now with wildfires, you know, Australia has its bushfires, the US has wildfires. In the UK, we actually saw the sea freezing in Shetland, which is also an impact of climate change, which has not been seen for many decades. So we saw that this winter. So we're starting to see impacts of climate change that are actually affecting the global north as well, which may help to mobilize action. So the parallels are clearly kind of complicated, but none of them are actually particularly optimistic for this. So then that brings on to the question, well, how do you engage a wider variety of actors in the face of all the incredulity or disbelief or skepticism or other pressures? And I think there you do have to kind of put on the optimistic hat and say, well, yes, there is a lot of skepticism, but equally there are a very great many actors at many different levels who are working very hard to raise awareness and tackle climate change. And if we actually start to engage with those actors at different levels, rather than leaving it to states who will, you know, centrally prioritize predominantly economic matters, then we might actually be able to be more effective. So many of the partners already exist and many of the partners are willing. And then there's a question of education. If we want to take action to combat climate change that happens at many different levels, then education and raising awareness are going to be absolutely key. So I think that in terms of developing the partnerships, then education is going to be key, but that is something that is best done at the kind of closest proximate level in order to be most effective. And in that context, you can start to point to the local impacts of climate change, for instance, not the ones that are seen globally, but the local ones, like, you know, the sea freezing in Shetland, like the bushfires in Australia, like wildfires in the States, or many of the others. So you can start to persuade local populations who previously thought climate change is something that happens to others, that actually, no, climate change is something that also affects them and their lives. And you can see it in fish stocks and fishery supplies, etc. So it's something that affects their lives. So then you can work at that level. And then I think there's a whole other issue about how we work and use private law and the blurring between private and public law, which comes into this as well. But I'm out of time.
Okay, let me just go with Antonia, and maybe we can wrap up at the end. You highlight, Antonia, that embracing food sovereignty and dismantling of agribusiness is one of the imperatives of the agenda. You accept, and everyone will agree, that there will be a radical action, and propose to bring more constituents to the table as well. But let me for a moment say, okay, we agree on that. What will be your approach to WTO disciplines to achieve this, Antonia?
So this is an excellent question, and this is so what does it originally started as? I have to preface this by saying, when we originally put together this panel pre-COVID, what I had envisioned this as being has changed so radically over the past year of COVID that it's really almost like starting over from scratch. And so a lot of this is kind of new and nascent and formative in my mind. I think one of the big surprises, I mean, maybe it shouldn't have been a surprise, but it was seeing, you know, supply chain disruptions. Locally, I live in a community that has very robust local agriculture. And when there was no food on the shelves of the big box stores like Walmart and Kroger, suddenly like everyone was buying everything from local farmers. And so that really got me thinking about food sovereignty and researching a little more into this. And so a lot of this is very formative. And I think, you know, you raised a very good point. How do you bring in the WTO disciplines? I mean, this is a little bit of a square peg in a round hole problem, right? Like the WTO was definitely not designed to do this, but that's what we have. So that's kind of what we have to work with. And this goes back to Emily's point that, you know, we have these institutions, we can't just start from scratch. Like the world is not in a place, this is not post-World War II. We're not all on the same page. We're not about to start with new multilateral institutions. So that means that we do have to maybe carve away the square edges of our square peg to get it to fit into that round hole so that we can actually get some solutions. And I recognize that that can be far from ideal and very difficult to achieve. So some of my thoughts on this goes back to some of my earlier scholarship on how to get the WTO to give force to the Paris Agreement. And in this earlier paper that I actually presented at SIEL a couple years ago, I suggested using a combination of waivers, special and differential treatment measures like those that are found in the Trade Facilitation Agreement, in maybe the context of a multilateral or plurilateral agreement focused on climate change, and also reflecting on the importance of the term sustainable development in the preamble of the WTO agreement. And I think all of those points can still be validly applied to food sovereignty, even though that is, I mean, my decision to sort of jump into agriculture and food sovereignty is probably, poking the most contentious issue that the WTO deals with, and perhaps the issue that it has dealt with the most poorly over the history of the WTO. And there's a lot of areas that have been, not super well handled, and a lot of areas that have been well handled. But I think, some of the questions that arise, I mean, the danger with existing special and differential treatment measures, even those that are found in the Trade Facilitation Agreement that are capacity building related, is that they're not really centered on the needs of the countries receiving the aid as much as they are avenues to improve trade possibilities and to reduce costs for global north countries who ultimately benefit the most. I mean, in trade facilitation, capacity building ends up making it cheaper for global north customers, right? Like that's what the end result of a lot of that is. I think in relation to food sovereignty, the number one thing we need to be thinking about is ending fossil fuel subsidies. And that is an area that there has been a lot of attention. There have been a number of countries that have started voluntarily notifying their fossil fuel subsidies. There's a move towards greater transparency in this area. That alone is not going to be enough, but ultimately, I think there is a growing global consensus that we need to do something about fossil fuel subsidies. And the WTO ends up being the best forum for that because it's the only forum that has a robust subsidies regime. Of course, as we all know, the SCM agreement, though, is a hot mess. And the SCM agreement isn't exactly well suited to addressing any of this. So, I would love to see the SCM agreement renegotiated. Wouldn't we all love to see that? But ultimately, that's where I have this really, I feel like a cop-out kind of position, which is the fallback is waivers. The fallback is waivers kind of along the lines that people have advocated for building renewable energy sources and potentially having waivers, from things like domestic content requirements since, the panels and the appellate body have found that violates WTO rules. Having something in the form of waivers that go beyond the food security exception that allow for more agricultural independence. So I'd like to see a waiver that allows for increased tariffs on goods that carry with them a certain burden of emissions, right? Like agribusiness products would fall under that if you're shipping green beans from Kenya to the UK or asparagus from Peru to the United States, slap a tariff on it. But of course, that's antithetical to some of the basic principles of the WTO. So I would like to see that. I would also like Santa Claus to be real. I really hope my kid's still sleeping. But, these are things that it's very, like, there's a laundry list of wishful thinking, and then there's what can you actually achieve in the context of this. And that's where I think at least putting ideas out there and saying, we could do this. And this is a possibility. We are not constrained by the rules that are on paper. And if there is the political will, you can move outside of it. There are flexibilities inherent in the WTO. And if we just sort of give up pushing on it and say, well, it's the WTO, it's a neoliberal institution, we just have to live within its confines, then we've got nothing. And I think the WTO, I mean, maybe this is the vestiges of my naivete from when I was young and fully believed that the WTO was perfection itself. I have become bitter and cynical over the years, but, I still believe in it as a place that countries come together and can negotiate solutions. So I don't know. Those are my 2 cents.
No. Let me pick up on that. Let me exactly pick up on that, because that goes to Gregory's point, and you and Emily make the point that is the only thing we have, the WTO. Let's look at, but at the end, and this is not a cliche. You are talking about a trade agreement, and at the end, when dealing with forestry management, how would we reconcile the regulations if we are going to look them under the prism of WTO disciplines, notwithstanding that already there have been these, the WTO and the appellate body and the panels have tried to draw a balance between trade interest and other societal values. But how can we achieve that if at the end it is a trade agreement? Gregory.
So thanks. Yeah, I mean, I think it's I don't see a tension necessarily. So I think the problems with the way that the WTO deals with it is structural and political rather than the legal framework. So I don't see the trade rules as being about trade qua trade, right? They're not actually about, the WTO rules aren't about getting people to be free traders. They're about mitigating the impact of regulation on trade. I think even actually with tariff-based policy, but certainly with subsidies and certainly with others, right? We're not prohibiting all subsidies. It's not, it's not state aid. We just care about subsidies that distort trade. That's basically the objective. Now, whether it does that effectively or not is another question, but that's kind of the aim, right? I think the issue is, in terms of forestry management, an entirely legitimate objective, which is we want to encourage trade in timber products. We just want to make sure it's the right type of timber product. That's basically what it comes down to. So how do you then go about doing that? Well, the TBT committee should be the place where you say, look, I've got this regulation, it's going to affect trade. There's an objective for it, so it's fine, right? Bog standard, TBT, vanilla, no issues. The issue is the TBT committee, right? Members are wildly more conservative interpreters in committee of the WTO rules than panels or the appellate body ever would be. Right, and understandably so. It's the space of contestation, right? So they go, and we see, and so that's part of it. And the other part is the rhetorical style, right? Which is very rarely to call out for a binary issue like discrimination, right? It's nearly always, out of the 650 specific trade concerns of the TBT committee, some 60, well, the largest number are we need more information, and then the one after that is this is too burdensome. So, of course, it's the usual thing, right? We fully support your objective. We couldn't support you more. We're totally on board with this. We're just worried that this is more burdensome than necessary. That dynamic, in terms of pulling back burdensome regulation and trying to balance what I think would be a normal process of contestation that also takes place internally, domestically, this is just the international facing bit of it, that would normally function if you had some sort of balanced power relationship, but we don't. And usually the problem would be the other way around, right? So Chile wants to introduce new front of pack labeling for public health to deal with obesity. They have to face off and fight their way through the TBT committee and elsewhere. And they'll do it in the end, but it was a lot of resource, a lot of effort, WHO working to support people. Fine, keep fighting, you're fine, okay? The problem here is these are measures that are leveraging market size. So they are only being proposed by the very largest players, who necessarily power comes from regulatory pull. So there you've got a real challenge. And both the US and the EU in very different ways. The EU legislative process is so wildly nightmarish that once you've gone through all your trilogues and consultations and everything else, and you actually have a draft legislative process, the institutions have no interest in changing it whatsoever. So, what's the examples where we've seen it happen? The very early days of the cosmetic test ban, animal testing of cosmetics, and the EU just delayed implementation of the directive. That was kind of the consequence of being pushed back. Not to say that it's a good or bad measure, but rather just like it's not the same rule that applies. So then, what do? The other TBT design, which actually it's not a bad bargain, right? Regulate as you see fit, so long as it's legitimate and you don't discriminate. And if there is a standard, please use the standard. The issue that we have is we're getting into sectoral issues where the ISO doesn't deal at that level of granularity, right? And the ISO is by no means perfect. I'm not suggesting it is, but it is public in certain regards, more public than private standard setting agencies. And but the problem is, as with all public standard setting bodies, there's the concern which is it's low ambition, what you do, generic and low ambition and so on. But then you have a world of private standards might be more specific and might be more sort of responsive to demand, but they have the classic problem of private standards, right? They are having a huge impact on traders in the how effective they really are. When I buy my cod from Marks and Spencer's and it has a pretty MSC certificate on it, and I feel like I'm a great person because I think that that's totally sustainably fished. I mean, is it really? Who knows? I don't. That one, I want to speak ill of the Marine Stewardship. I'm sure they're great, but like, you know, a lot of them aren't. The fact that we have FSC and then we have rainforest speaks to the fact that there are criticisms and concerns around that process. And so it's like, how do we get the more narrow sectoral stuff with the more public area? That's why that carbon footprint ISO technical standard is quite interesting, because it's the first one where the ISO, or the first main one, where the ISO says, this actually does relate to how you agree on something, how you say. It's not about the product characteristic at the end, which is usually their priority, right? They kind of avoid this. So here, no, we'll shift around that. And that's faced a lot of criticism, exactly because some countries will say, we don't have access to renewables in the same way that others do. So our product is worse in terms of carbon footprint than others. And that's unfair. Now, there's questions, at least some sort of acknowledgement that if the ISO has set out standards of how you do this stuff, that is what you need to follow. And you cannot implicitly or explicitly support private standards that do not align with those general principles. And that would be my concern, because we have SE certification where they've actually had to release a statement saying, this doesn't meet the EU timber regulation requirements. Just because you have the certificate doesn't mean you automatically comply with the EU timber regulation, because a company had FSC certified timber and then got done in the court in Manchester because they went, we just assumed we'd be fine. You know?
But it's the same thing that who makes the rules. But I mean, I will go with Gillian and Gillian, and first of all, to try us to take us to another avenue, to help us like go through the Paris Agreement route. And what will be the hurdles, Gillian? We know that the 6.8 that you quote has some substantive, you said about substantive content that has not been agreed. So what would be the hurdles, and how do you make it compatible with WTO commitments?
Yeah, thanks, Ricardo. It's another excellent question. And as I see it, it raises three main issues. The first is that what's in paragraph 8 may be settled in the sense that it's in the text of the treaty that an NMA must do all these things. It must assist in the implementation of the parties' nationally determined contributions. It must be available to parties in a coordinated and effective manner. It must take place in the context of sustainable development and poverty eradication. It must be integrated, holistic and balanced. It must enable opportunities for coordination across instruments and relevant institutional arrangements. It must enhance public and private sector participation in the implementation of nationally determined contributions, but it's still not clear what some of these phrases will ultimately mean. And the second issue is that there are two broad conceptions coming out in the negotiations between the parties and the CMA guidance of the role of paragraph 8 and NMAs. So the like-minded developing countries want it to facilitate access by developing countries to mitigation and adaptation support from the wealthy countries to help the developing countries build up their nationally determined contributions. So under paragraph 8, they'd like to see, for example, a monitored register of offers and requests. They'd like to see that established. But the other view is that NMAs should facilitate the cooperative adoption of measures addressing areas where market-based approaches are not the best. And examples cited include where commercial purchasing decisions, for example, heating units for large buildings, are being driven by reasons other than the mitigation of emissions, or where carbon leakage could be an issue. That said, the CMA has incorporated both of these conceptions into the latest working draft of the rules, and it has also affirmed that they needn't be seen as mutually exclusive. The third issue your question raises is either a problem or an asset, depending on how you look at it. So Article 6 is the only article for which the Paris operational rules haven't yet been drafted. The last technical committee meeting, which took place last month, didn't make any progress on this, but the parties they might be more ready to agree by the time we get to the next COP in November. So in a sense, the bad news is that not enough has yet been settled about Article 6, but the good news is that much about Article 6 is still open for decision. But if I can just step back for a moment and take a broader view of what your question is really asking. James Backus said, even before the Paris Agreement was finalised, that we need to draw a legal line up front between those climate measures that are going to be permissible and those that aren't. Ideally, this legal line should be drawn, to use his phrase, in concert, but still no real thought has been given to it, either in the UN climate negotiations or in the WTO. We still have no structured communication between the two worlds. On the WTO side, perhaps the fora that deal with the interface most directly and regularly are, as Greg says, the TBT committee and the subsidies committee. So, for example, when I looked a few months ago, the minutes of TBT committee meetings since 2005 revealed discussions of 15 technical regulations dealing with greenhouse gas emissions reductions proposed by WTO members. That's where the discussion, that's where the consultation is taking place. On the UN XXI side, the most active fora are probably those on what are called the impacts of the implementation of response measures. But the focus there is more on support for a sustainable transition to a low greenhouse gas economy than on the trade effects per se of mitigation measures, although there is also an emerging awareness of the potential role of paragraph 8 in addressing the competition dimensions of those impacts. So I guess to sum up my answer to your question, obviously a formal, high-level and dedicated dialogue would be the best, but until we're there, paragraph 8 may play a valuable role, if only through necessity.
Thank you, Gillian. I think you have behaved so well that I think we have good time to give another round. So let me just put some questions out there, some reflections, and based on what you've been saying, and get your views, and I will make a final round for the four of you. The first is this: is this only an issue of awareness and education, as Emily is saying? It's only an issue of, or at the end, climate change is, as Amit Ghosh says, is an issue of culture. Culture generates desires for vehicles, for appliances that are among the principal drivers of the carbon economy. So aren't we just don't need to educate, we need to change the culture. That's the first big question that I have. I mean, and how do we do that? Because Emily and Antonia mentioned some of the disasters that have already happened in light of climate change, and things have not changed. We're still discussing this. There are still skeptics about the issue. So how do we address that? The other thing is, and talking about WTO disciplines now, should we take what we call the granular approach? What is the granular approach? We go through disciplines, and Gregory says, okay, TBT, we address the TBT issues, we address in this way, or we address the subsidies definition in this way, and we address carbon tax this way, and we finish, hopefully, a fisheries negotiation. Don't we need? Is this enough? Do we have time to go through every granular, everything that comes out? Now there's a big discussion about carbon tax. There's a big discussion about fisheries. But there are some of the issues that you touch upon that have not been even discussed how we will address them. So the radical change that Antonia talks about, wouldn't that be change the whole paradigm of how you read disciplines? At the end, the burden is on the side of showing that the measure is not more restrictive than necessary, blah, blah, blah. So it shouldn't at the end, my concern is everybody talks about 2030 when it talks about climate change, 2040. The time is tick-tack, tick-tack. It took 50 years to get an agreement on to better disciplines on goods. It took how many years we still have are working on services? How many years will it take us to have disciplines on environment and climate change and to address these problems? And do we have time? And the other one is the WTO the right place? At the end, with all the things that you are pro WTO. I think I am also pro WTO, but is the WTO the right place to start the discussion now, or should we start thinking about another institution in trying to address, because all the problems and because the main actors and drivers of some of the problems are within WTO and have a voice, very strong voice in the WTO. And at the end, the WTO is a trade agreement. I think we shouldn't forget that. So, I made a lot of comments, but I just tried to elicit the discussion. And also, Gabriel, in talking about this granular approach, talks another approach about whether we should use the enabling clause as an avenue for imposing in development. So, at the end, you tell me. Okay, I will give you 4 minutes, just and then maybe a little bit more. So, but let's take 4 minutes each one. So, Emily.
Okay, right. So, is the WTO the right institution? I think this actually goes back to the point that I've made, that Antonia's made. I think that also Greg's made it, although perhaps less. The WTO is an institution. It has tremendous power. It has tremendous buy-in and influence, and it has binding dispute settlement. So it has the power to ensure that states will, okay, in theory, okay, to ensure, but it has greater binding force than many other bits of international law. So I think that, pragmatically, it goes back to this issue that we have to work with the institutions we have, particularly, as you've mentioned COVID earlier, particularly we're in a context in which states will be looking inwards. They will be looking for, protecting their national interests, so that this is not a time we're going to be able to create a new international organization, however much we might think that's actually the more effective answer. We have to work with what pragmatically we have. So it exists, it has power, it has the potential for enforcement, although that comes down to political and economic power in the end, but it has that. It's stronger than lots of the other bodies of international law. So it makes sense to work with the WTO. Then I think you go to Greg's point, that is a view that I share, that actually the question is how we interpret, how we view the WTO rules. And it's actually about locating the WTO